welcome to Be Informed. My name is Carl Buhariwala, and I founded Be Informed to help people make good decisions. Today, we're looking at separation and divorce, and we are joined by Amanda Vella of Pearson's Lawyers, who will be talking about thinking of separating in Australia. What do I need to know? Before I proceed, I would like to acknowledge the traditional owners of the lands on which we are meeting today and pay my respects to their elders, past and present. Today's session is being recorded in Australia, and the laws being considered is in relation to the Australian jurisdiction, and it's as of this month. So if you are relying on this information in the future, please do consider its currency. And if you are relying on this information from a jurisdiction outside of Australia, please do check its relevance to you. Also, all information being shared today in this session is general only. And if you do have any specific queries about your personal circumstances, you may wish to engage a professional, such as a lawyer in this case. In terms of housekeeping matters, if you do have any questions, please do send them through to me in the chat function, and I will relay them to Amanda, who will kindly answer them in the Q&A section of this session. And Amanda's also kindly prepared a one-page handout, which I will share with you by email to those that have registered for this session. The session is also being recorded, so if you do have to drop out, come back later and what have you, don't worry, you can view it, the whole session online at a later time at your leisure. So feel free to take that as you will. Without further delay, I think I can hand over to Amanda now. I've covered up on all my initial bits. So Amanda, over to you to take it away.
Thank you, Carl, and thank you for the opportunity to present today. As Carl said, I'm a partner at Pearson's Lawyers. We predominantly do family law and intervention orders. Today, what I really want to do is provide you with some guidance with separating, what happens to property, what happens to children, some safety issues, and give you an indication of the things that you need to think about and head you toward the right direction. So we'll start. And I just want to say that if you're thinking of separating, or you know someone that is separating, you're not alone. There are many people who separate. The most recent data that I could obtain from the Bureau was that there was 56,244 people who obtained divorces that year. And I think that those figures have definitely increased since COVID and the pandemic. Some common questions that I get about divorce and separation and what people can and can't do is, can I get a financial agreement if I'm not yet divorced? The answer is yes. Divorce is a piece of paper that says, or a divorce order is a piece of paper that says you're no longer married to somebody. And a financial settlement or getting consent orders is separate to that. But what you do need to know about getting a divorce is that you need to be separated for 12 months before you can apply for divorce. Being separated, you can be separated under the same roof. However, you need to file an additional affidavit explaining your circumstances and explaining how you were separated to the world at large. The most other important thing you need to remember is time limits. So if you are divorced, then you have 12 months to commence proceedings in court, unless you get an order for leave to proceed, what they say, out of time. And if you are a de facto couple, and you've got 2 years from the date of separation until you can make a financial settlement. So those are the important things about divorce and separation. The next thing we're going to speak about is a very important topic about what happens to the children. Now, as you can imagine, children issues can be very, very technical. There can be a lot of risk issues. I've narrowed it down to a couple of scenarios that, again, can give you a general idea of what a starting point could be. So if you are separated and you're wondering what happens to the kids, I've broken it up to if you have an agreement about the child arrangements, and if you don't. If you have an agreement and you're amicable with your partner about what will happen to the kids, and some arrangements could be, for example, that the children live 50-50 with each parent, then I would recommend that you would document that in a parenting plan, just so it's written down and everyone's clear about when the children get dropped off, when they get picked up, etc. And that might be enough for some families. Other families might need to get something from the court, which is called consent orders. So you can change that parenting plan into consent orders. And why you would do that is parenting plans are not enforceable by a court or anyone. They are just that, a parenting plan, a documented piece of paper that outlines everything. You might also need to get consent orders in situations where there are intervention orders, which prohibit a party from spending time or communicating with a child. That intervention order will have a specific exception to say that the respondent can do anything permitted by a family court order or a parenting plan. So you might need orders, or you might need a parenting plan documented. Now, the other point of view is if you, or the other scenario is if you don't have an agreement. If you and your partner can't, ex-partner can't decide on what happens to the children, then you will need to go to mediation. There are private mediators that you can engage in, and you can bring lawyers to that mediation to try and assist you in trying to come up with a parenting plan, which you'll eventually put into orders. Excuse me. Or and after that you've got your private mediators, and then you also do have government-led organisations such as Relationships Australia that do organise mediations. But those there are wait times for those, and some of them you're not permitted to bring lawyers. Once you do attend mediation, again, if you come up with a parenting plan, you can use that, or you can use whatever agreement you come up with and apply for an application for consent orders. If you don't come with an agreement, the mediator will provide you with something called a Section 60I certificate, and you use that certificate to show the court that, yes, we've tried mediation, unfortunately that hasn't helped, and we would have to go to court. There are scenarios where you would have to go to court straight away, and that might be if there's risk issues such as drugs, alcohol, family violence, or in intervention orders. Again, my advice would be, if you've got specific risk issues or specific, certain a list of circumstances, go and see a lawyer, have a free consultation, know where you stand, and talk about possible outcomes, or what you can or what you should offer. Sometimes with children, it does get a bit strategic, or there are things that you need to be aware of before, such as if there is risk issues, then you need to act like there are risk issues, obviously. For example, lawyers might recommend supervised time, and that needs to be in place until you're satisfied or you have evidence that there are no longer any risk issues, and requests that the other side provide things like drug screens or hair follicle tests, or go and have supervised time with a supervisor and produce those reports. And that will alleviate any risk and ensure that the child is no longer, or try to ensure the child is no longer at risk before some unsupervised time. But again, those specific things you can get advice about if you go and see a lawyer. The next thing I'm going to talk about is property. And you may have read, or you may have heard of what's called the 4-step process, which just assists in deciding how assets and liabilities should be divided. Now, I always say to my clients that we avoid the court like a plague because it's so expensive, it's timely, it's also taxing psychologically on many, many clients. But we use the same precedents and the same law, obviously, as the Family Law Act 1975, to provide clients with some advice and indication on what they should walk away with at the end of a relationship. So the 4 steps are, the first one is identifying what the value of the property, liabilities, financial resources of the parties. So essentially what I tell my clients is, if we were going to divide a pizza, what's on the pizza to divide? That's the most easiest way I can explain it to you. The second thing, and just on that, if there's issues of value of what, for example, the former matrimonial home is worth, then we get third-party valuers to value those properties. So we can value property, we value businesses, we value cars. I've just got one case when we're valuing number plates, anything. So we artwork, jewelry, we value things that by a third-party independent value if we can't assess the value. If we don't, sorry, can't agree on the value. The next thing, once we know what's in the pool to divide, what assets, what liabilities, what financial resources there are, is what's called contributions. So the court's going to make adjustments to the parties depending on financial and non-financial contributions. For example, the main contributions that we look at, the first one is initial contribution. So did one party come into the relationship with a greater value of assets? Where this is most important, for example, is if there was a relatively short relationship, for example, of 2 years, and one party brought in $500,000. They, at the start of cohabitation, so when the parties started living together, that's the relevant date, one party had a house with an equity of $500,000. 2 years later, for whatever reason, the parties worked together and the total value of the whole asset pool is $1 million. What the lawyer or the party that had 500,000 at the start of the relationship would argue that they had a greater initial contribution that they should receive an adjustment for. And I'll explain adjustments a little bit more in the last step. But we look at initial contribution, so what did the parties come into the relationship? Then we look at during the relationship, were there any gifts, redundancies, or inheritances received from a party? And again, if, for example, an inheritance was received by a party very late in the relationship, close to the date of separation, then they would, well, I would argue for that party that they should receive an additional adjustment because they've contributed something that the other party hasn't, or the other party hasn't contributed at all to very late in the relationship. The next thing that we look at is what's called future needs. So the court looks into a crystal ball and sees or makes an assessment as to whether a party should be given more of the asset pool at the end of the relationship because of a need. What these examples of future needs could be if a party is the primary carer of dependent children, or if one party earns significantly more than the other, there's an income disparity. So the court says, I think the party who earns less or hasn't had the opportunity to work because they've been at home for whatever reason, looking after kids or whatever, they should get more of the asset pool because there is a significant income disparity. And then the last step is that the court's going to assess the effect of the findings and consider what orders would be just and equitable in the circumstance. And if you did go all the way to a trial, the court, you'll see and you'll be advised that the court has a vast discretion there. But I'm going to give you just an example so you can understand how these 4 steps are applied practically. So just off the top of my head, let's say there's a pool of $1 million, a property worth with an net equity of, 800,000. What equity means is the value of a property minus the mortgage or liability. There's a couple of cars, some shares, some superannuation, and the net equity is $1 million. If this was a relationship of 30 years, the court would consider this a long relationship. So if someone brought in an asset of $20,000 30 years ago, there is a precedent called the erosion principle, which means that $20,000 initial contribution would have eroded. The effect of that contribution would have eroded, and therefore that party wouldn't get a contribution. So we wouldn't disregard it, but it wouldn't have much effect. So we're still sitting on each party getting 50-50. The court's going to start with 50-50 and then make these adjustments. So we look at other contributions. We could say that one of the parties, let's say the wife, inherited $300,000 a year before separation. So if you look at that, $300,000 in a pool of $1 million is probably quite significant. So the wife might get an adjustment of 5%. So she's now sitting on 55, and the husband's now sitting on their other side. And then it looks at future needs. So if you look at this scenario, perhaps the husband earns $200,000 as an engineer, and the wife is a teacher earning $60,000, and she's only working part-time because she's looking after 2 dependent children. So the court's going to give the wife an extra adjustment because of the income disparity and the fact that she's the primary carer of 2 young children. So that's how the court will make those adjustments. So again, they'll say, let's start with what's the asset pool? Let's start with 50-50. Let's look at the contributions. Are there adjustments to be made? Then let's look at the future needs, and are there any future adjustments that need to be made? Again, always best to get specific legal advice in relation to your situation. It can get very complex in terms of even step 1, the asset pool. There might be complex trusts, businesses that need to be taken into consideration. There needs to be disclosure. All of these things need to happen before we can go through the 4-step process. And a lawyer can really give you, some specific advice about where you stand. And that's very important to know in case you're perhaps negotiating with your former partner before you even go to a mediation, for example. The next thing we're going to look at is safety in separation. So this is what we tell our clients to ensure the safety of their assets, the safety of their children, the safety of themselves are a few of these things. So one, a lot of people don't think about this, but to secure your email and communication platforms. So when you engage a lawyer, they're going to be sending you very confidential information. They're going to send you advice specific for your side and your point of view. We don't want the other side to see your emails. So sometimes we recommend, if there are any concerns in relation to safety, in relation to your email and communication platforms, that you open another separate Gmail account or whatever you use, whatever platform, and use that only for your lawyers or only for your family law dispute. Other things are securing your banking procedures. So what that means is ensuring your passwords, all of those things in terms of your bank, your superannuation, that they're all secure, safe, and the other side doesn't have access to it. We've got there lodging a caveat. So what that means is sometimes an asset is only in one party's name. That doesn't mean it doesn't get included into the asset pool in step 1. But what that means is a party whose name is not on the title, for example, they don't have any security over that asset. And that means the other party can deal with that asset as they wish or unilaterally. So what we advise our clients is that if there's a property, for example, in a sole name of the other side, that we lodge a caveat on that property. That means that the other party does not have clear title and they can't deal with it as they wish until the matter is finalized, and we remove that caveat. We advise clients to create a new will, after they finish their property or even during, in case something happens to them while the dispute's still going. Your wishes are documented in your new will. Another thing we've got there is to change nominated beneficiaries. So what that means is superannuation, you'll have nominated binding beneficiaries. So sometimes, or most often, people will put their spouse. If something happens, their super will go to their spouse, or any insurance entitlements or anything like that will go with their spouse. It's just a quick, simple call to your insurance company to change it to your children or to your whoever you want to nominate as your binding death nominee. Sometimes you can even do it through your superannuation app. I've got there as well, consider an intervention order. So unfortunately, there's a lot of cases where family violence is involved. And I would say a majority of my cases actually have intervention orders going on at the same time, unfortunately. So if you are a victim of family violence, and that could be physical, that could be emotional, sexual, financial, you can get some advice from us or from Women's Legal or whatever to get an intervention order. Often if there's family violence and the police are involved, that they will apply for an intervention order on behalf of an affected family member. Sometimes it doesn't work that way, or it's not that easy, and you need to apply for an intervention order on your own. You can get assistance from our firm or from Women's Legal or Community Legal Centre in order to assist you in that process. And there are a lot of resources online on the Magistrates Court Victoria to assist you with applying for an intervention order. But unfortunately, sometimes applying for an intervention order is necessary to secure your safety while you're being separated. Next is my next slide is how to separate stress-free and inexpensively. So my first point is go and see a lawyer. I know at Pearson's we offer 30-minute free consultations, and we can go through all of this with you specific to your case. It's very important that you do that because a lot of our clients, sometimes, not a lot, but some of our clients come and they say, I've already negotiated this deal. Can you write it up? And then when we go through the law, the 4-step process, well-established precedents in relation to children arrangements, it's not in their best interest, but you've already started on this playing field and you're changing the goalposts, as they say. So make an appointment with a lawyer and know where you stand, so you know exactly what documents you need, how to secure your platforms, all of those kind of things, and where you should begin in the negotiation stage. And often when you're separating, you're not, sometimes in the right state of mind, and getting that third party, independent, objective, opinion about the law and what you're entitled to will really put you on the right track. Next, I say to my clients, after you see me, if it is safe to do so, try and work out as much as possible with your ex-partner. A lot of firms bill by the hour. So the more correspondence there is, the more exchange and disclosure there is, you're going to be charged for that. And I know with myself, I'm very transparent about costs, but some people might not be, I don't know. But the more lawyers interact, the more expensive your bill comes. So if you can try and work out as much as possible with your ex-partner about children arrangements, or have the parenting plan, roughly drawn out, and then we'll get some legal advice about specific things. For example, I've got a case at the moment where there's an NDIS assisted program, and I've got in my head, I've got a lot of cases that happen and problems that I can envision happening. So I've got specific orders in relation to how what we should put in the parenting plan to try and alleviate any stress or future problems. Those are the kind of specific things you can get advice about. But if you can sort out as much as you can with your ex-partner about parenting children, the value of assets, whatever, then you can come to your lawyer, or after you have your first consultation, you then say, look, I've taken your advice on board, I've spoken to my lawyer, I've spoken to my ex-partner, sorry, and this is what we want to do. And then it could be as simply as drafting what's called a binding financial agreement, which is essentially a contract between the two parties that explains what assets are there, what the contributions are, what the agreement is, and then you both sign it off. And you need to get lawyers to witness it and provide you advice. But that could be a very simple and relatively inexpensive process. So my tip to you is, if you can, try and work out as much as you can with your ex. In some situations, it's never going to happen, but in some situations, it can. Just want to talk about after the 4-step process, and if you've come up with an agreement, I'm just going to touch again on how you actually finalize the matter. As I said, you can go down the path of a binding financial agreement. And as I said, that's a document, it's a contract essentially that allows you to not use the family court route, and it's a contract that you both need to get legal advice on, and you both about the disadvantages and the advantages of that agreement, and you both get it witness signed, and then that agreement is effectively it, you do the settlement and whatever that agreement says. The other way is consent orders. So consent orders, you could get financial orders. So what happens to the house? The house can be sold after all costs and commissions are paid, how the house is going to be divided. You have your information about your superannuation split, who retains what cars, etc. That you can put in a consent order with an application, and you can also get orders at the same time in relation to the kids. So you can get property orders and financial orders all in the same application for consent orders. So that those two ways are probably the most stress-free and inexpensive ways to sort out your family law dispute. Again, if that doesn't work, or if you've negotiated by letter as much as you can with your solicitors, then the next thing to do is a mediation. That can again be for property or parenting. And if that doesn't work, then you would make an application to the court. And unfortunately, an application to the court is very costly, and there's a lot of steps, and court is expensive. But in a lot of cases, or in some cases, it's necessary, and you need to go down that route, not only to get financial orders, but it might be to get preventative orders, like injuncting someone or stopping someone from selling an asset that's in their sole name, or dealing with a business that one party doesn't have power or control over. So it might be that you have to go to court straight away. But again, you get that specific advice from a lawyer to give you, hopefully, a step in the right direction, and can point out some red flags that need some prompt action. And I think that is it from my side. Hal, any questions?
Thanks, Amanda. That was a really thorough presentation. So just to remind you, that's Amanda Vella of Pearson's Lawyers. Her details are on screen. So if you do have any specific questions, please do ask her directly. We'll now move into Q&A. And just before we get into that, Amanda, I just want to remind everyone this session is being recorded. So if you did join late or have to leave early, you can view the entire session online through our YouTube channel. And Amanda has kindly prepared a one-page handout as well, so that will contain a summary of what's been discussed, and I will share that with registered participants following today's session. So we'll get straight into Q&A, Amanda. And the first questions that I want to go through are, what happens if someone's married overseas? Can they get divorced in Australia?
Yes, that's actually more common than you would think. You can get divorced in Australia, but you need to have some connection to our jurisdiction. So you would have lived here for 10 years, or one of the parties is an Australian citizen. So what that means would be, when you apply for your divorce, you fill in your application, you'd have to provide a marriage certificate. If your marriage certificate is one from a different country and in a different language, then it needs to be translated. And you'd also have to upload onto the Commonwealth portal. That's how you do it. You need to upload the Australian citizenship certificate of either party to show that you have a connection, or one party might be a citizen by birth, and in that way you don't have to. But even if you get married overseas, you can get divorced in Australia, but you've got to show that connection to the jurisdiction.
Mhm. Perfect. Yeah. And when we talked about the four-step process with the asset division, it also captures liabilities as well. What happens with loans? So, the parties might have taken out a loan in their names jointly. How does that get separated? I guess that'll be hotly debated, right, as to who gets the higher percentage of repaying the loan.
Yeah. So assets and liabilities, so loans, they all get put into the asset pool to be divided. So it's not just the asset, it's any loan attached to the asset or any personal loan or credit card that all goes into the pool. So um, even if a loan is in one party's name only, that's put in the pool and is considered a joint liability. So that needs to be dealt with.
Right.
And what I forgot to mention is with loans, another way to secure um, your financial stability while getting divorced or separated is if there is a loan in joint names. I always tell my client to ensure that they contact the bank and make sure that you need two signatures to further draw down on the loan. That's again a quick call that could save you a lot of heartache. So and just to go back to your point, Carl, any liabilities, loans, or assets either in a sole name or in joint names, they all get included in the pool to be divided.
Right. Yep. So good to know that, you might have a big asset pool, but then of course the liabilities will also, take away from that.
That's right.
So don't forget about those um, liabilities. Yeah. And Amanda, with children, you talked about, the best interests and how that all gets dealt with. What happens if
Yep.
one party to the marriage or the couple, but they want to take that child overseas and live with that child overseas, right? How does that all work?
Yes.
Uh,
So um, you can do that with the consent of the other party. But what I would recommend the non-traveling parent, or what I would advise, is what if they don't come back? Um, so there is what's called Hague Convention countries. So that's a list of countries that has a treaty with Australia that says, if a child's normal habitual environment is in Australia and a parent takes them, the ADF gets involved and you can make an application with the government to try and get that child back. But there are some countries that are not part of the Hague Convention. So I get very nervous when a client says, yeah, that's fine, the child can travel overseas or go and live overseas with the other parent, or the grandparents, because, they're going to come back in 2 years. But what about if they don't come back? So I would make clear orders. If they do agree, I'd have very precise, clear consent orders binding. But then again, sometimes those orders have to be registered, and you've had to make a whole new application in the other country to register those orders. So I think in a situation where so a child's going to go live overseas or travel overseas, that you have specific orders about if they're coming back, who's holding the passports, those kind of issues.
mhm. And Amanda, just on that point,
Yeah,
how does one enforce? So if there is non-compliance with the
yeah,
consent orders by either parent,
yeah.
how would one enforce that against the other parent to ensure that they comply?
It's a good question.
Mm.
So there is an application for contravention that you can make. Um, and basically a contravention is like quasi-criminal kind of application, and it is essentially that you're making an application to the court saying that the other party has contravened Order 6 of the orders made on this date. Consequences of that contravention are that, for example, if one party is missing out on a particular time, make-up time can be ordered. Fines can be made against the parent who's not is not complying with the orders. And in some severe situations, there can be a change of residence situation, and that's multiple contraventions. And the most dramatic or the most harshest penalties, someone can actually go to jail for 2 years for contravening orders. I haven't seen that yet, and it has to be a lot of contraventions, I imagine, but it is an option for the court to use.
Yeah, yeah. So I think yeah, better stick with what you've agreed to, right? Otherwise,
Exactly. Yeah.
the outcome might not be as what you intend. Yeah, and with the just back on the property point,
Sure.
Amanda, we were talking about the assets, right? How frank does each party have to be? Like if they withhold information about, they might have a really expensive watch or I don't know,
Yeah.
and things that they've been doing on the side, etc. What happens if they don't disclose that and later gets found out?
Yeah. So disclosure and giving full and frank disclosure is a very important part of the family law process. You are criticized pretty heavily if you don't disclose something. If one party is not disclosing things and we are in litigation, then we would always advise, or not always, but we can advise to subpoena records like bank records. We've subpoenaed sports bet accounts, we've subpoenaed schools, passport agencies, all these things we can subpoena. And if a party doesn't disclose something and it's found out later on at trial, for example, it really hurts their credibility in the witness box. So there is full and frank disclosure. The courts are giving a lot of cost orders against parties who are not providing disclosure timely and as ordered by the court. So it's very important that you disclose things. And when you make an application to the court, and you have to file what's called a financial statement that shows the court, gives the court a snapshot of your financial circumstance at the time. You're required to read the rules in the Family Law Act in relation to disclosure before you sign that document. So that's how important it is to disclose assets, liabilities, and the values, etc.
Mm. Yeah, definitely. Yeah, as a fellow lawyer, I cannot stress the importance of being honest in those discussions,
Yes,
because you can get into a whole lot of trouble
after
if
on.
you falsify or conceal the truth. All right. And Amanda, just on intervention orders, you mentioned, of course, safety in the process. If one party does take out an intervention order or family violence protection order or one of those
Yeah.
orders against the other party,
Mhm.
could that inhibit or hinder the discussions that need to occur for the separation or divorce, or is there an exception allowed for that? How does that all play out when one party's an IVO against the other?
Yeah, so sometimes in practical terms, the intervention order, a full intervention order will stop the communication between two parties, or prohibit the communication, but there will be an exception in the intervention order that will allow parties to attend a mediation or communicate about financial matters through a lawyer. So it might be that it becomes a bit more costly and expensive because you can only communicate about property through a lawyer. One important thing, though, is a lot of families think, or parties think, that because there's an intervention order and it's in place for, let's say, 12 months, they don't do anything about seeing their kids because they think that they don't have the power, or there's no avenue to negotiate that. But it doesn't stop you from making an application in the family court, and family court orders override the intervention order. So just because you've got an intervention order against you doesn't mean that you don't have the avenue to seek orders or to spend or communicate with your kids, but you might have to do it through a lawyer and through the family court system.
Mhm. Good to know. Yep. And okay, yep. Just so I'm just going to the questions, and then just on the children topic
Mm-hmm.
again. There was some recent changes, I think, early this year about the best interests. Just at a high level, Amanda, how do the interests of the children get captured? In in the child arrangements, do
Yeah,
they have a say, or is it
yeah.
impartial? Like, how does that work?
So there were some changes to the Family Law Act in relation to how the court determines parenting orders. Um, but the most important thing that hasn't changed is that the best interest of the children is still what's called the paramount principle. So any orders that are made needs to be in the best interest of the children. Your question in relation to do kids get a say or children get a say? It depends on the age and the maturity of the children. There are many ways in which the court uh, takes in consideration the views of the children. One of them is that they can appoint what's called an independent children's lawyer, and that lawyer is appointed by the court and acts as a separate party, and they're only that their aspect or their applications are only from the children's point of view. This independent children's lawyer can often interview the children and ask them questions so that, in a final hearing or a trial or when considering consent orders at any point in the stage of litigation, um, they have the children's point of view in their head, and that might, the independent children's lawyer also has to consent to the orders before they're made. So that's one way. Another way, and a very common way, is that a family report writer, so a psychologist, is appointed to interview the parents and the children and give the court a third party objective account of the family dynamic and provide some recommendations about what they think interim orders should be or final orders should be. So that's another way, and the children will get interviewed and the children's thoughts and views will be put into the orders. Also, if there's any Department of Health and Human Services involvement, child protection, reports are provided to the family court at the beginning, and they some if there are very severe allegations and heavily involvement with the child protection department will get subpoenaed, and they often would interview the children. We've also subpoenaed schools and obtained reports, and views of the children can also be obtained by getting those documents. So it's not a jurisdiction where the children are put on the stand, as they say, and questioned by the judges or the barristers. That never happens. But there are other avenues in which the court can obtain the views of the children.
Cool. Thank you. Um, I think the last question. So we've got one on pets, Amanda.
Or pets.
What happens to the furry friends or the fish or any other type of pet, I guess,
Yeah. Mm.
business?
There is some most recent case law in relation to pets and what happens. They are put into orders, believe it or not.
Right.
Um, uh, it isn't that common, but there are some emerging laws, not laws, but cases that are providing some precedents or, in relation to what happens to the pets. Essentially, I mean, it's all case by case basis, but um, they are considered property, and there has to be some kind of agreement about what happens to them. So it's becoming more common, but I haven't seen it too much in orders, but it is increasingly becoming more and more common.
Yep. Yep. Yeah, those beloved goldfish might, be point in the
I don't know about goldfish, but yeah, definitely dogs, cats, birds.
cool. And our last question is Just going, sorry, just bear with me, Amanda. Um, yeah, so just again on the actually there's one more that's just on the asset pool again,
Yeah.
discussion that we had earlier. Um, you gave a few examples as well. What evidence does the party need to provide as to, their commitment, their involvement in the relationship? Is it all just pretty much through affidavit? They will, pretty much go through their living arrangements and how they've been
Yeah.
working together, engaging with each other, and then the court then comes up with the percentage, or can the parties make their own recommendation as to percentages? Is there a bit more detail you could share on that?
Um, so in terms of the duration of the relationship, sometimes that's a highly contested matter, and um, that can have a little mini trial before a big normal trial happens. So it is highly contested sometimes because the longer the relationship or the date that someone started a relationship can have significant effect on contributions, excuse me, and what each party brought into the relationship. In terms of the evidence, it is affidavit material. So one party will say, when they commence the relationship, we've annexed into affidavits Facebook posts, movie tickets, postcards, photos of the evidence of the relationship. Other things are affidavits of other family and friends who have witnessed the parties be involved or go to parties or special engagements together. There's also things you look at whether the parties intermingled their financial situation and their finances. So it's not just affidavit evidence, but usually it is accompanied by evidence such as photos or um, Facebook posts, text messages, call logs, all of that. Um, so I hope that answers your question.
Yeah, quite a mix. And then I'm assuming, Amanda, you could also engage witnesses like, family, friends,
Yeah, they
or
would do
anyone
their
else.
own affidavits and provide evidence to the court
Yeah.
about, what they saw and what they witnessed and what they believed when the relationship
Mm.
started in
So
their eyes.
it can be quite revealing, right? You sort of have to get quite
It's
into
very
detail
revealing.
and disclose those matters.
Yeah.
Cool. All right. Well, that was sort of our final question. I think you answered the other question that we had about the evidence part, which sort of got captured into that last bit. So that was good. Um, Right. Well, thank you, Amanda. That was a really engaging session, and I hope those that have joined today have found that useful. I'll just again share Amanda's details on screen. So if you do have any specific queries, please do engage with her directly. Of course, the information shared today has been general only. So yeah, that's Amanda on the screen there. And that brings us to the end of the formalities. Yeah, please do follow us on social media, and you can check out all past sessions on our YouTube channel. You can view them at your leisure and share them with family and friends. This session is being recorded, so of course after today's session I'll make it available online. So if you have joined late, you can view the entire session at your leisure. And there's a one-page handout which I'll be sharing right after this session by email to those that have registered. So you've got a handy guide there that you can use for yourself or share with those in need. Our next session is on the 10th of July, and it'll be talking about workplace discrimination. So if you have experienced discrimination in the workplace, or know of anyone that has experienced such discrimination, then attend that session and learn more about that. But for now, I'll take your leave and have a good evening. Thank you again, Amanda, for your time. And bye for now.
Thank you.
See you, everyone. Bye.